A liberal Supreme Court justice, appointed by a Democratic president, just handed a devastating legal weapon to the side she was never supposed to help. And here's what makes this story different from everything else you're seeing right now. This isn't spin, this isn't speculation, this actually happened. And by the time you finish watching this, you're going to understand exactly why this moment is far bigger than it looks, and why it could directly determine which party controls Congress heading into the 2026 midterms. So let's get into it. Virginia sends 11 members to the United States House of Representatives. That number is locked in by the census. Right now, the delegation is split, 6 Democrats, 5 Republicans. A competitive purple state where both parties have a real shot depending on maps and turnout. But after Democrats swept the 2025 state elections, including winning the governorship, they didn't just want to hold their 6 seats. They wanted something far more aggressive. The goal was to flip the map so dramatically that Virginia could end up something like 9-2, maybe even 10-1 in their favor. One lonely Republican seat left standing. That is not ordinary redistricting. That is a political takeover. And here is exactly how they tried to pull it off. They pushed a constitutional amendment designed to strip power away from Virginia's Independent Redistricting Commission, the one Virginia voters themselves approved, and hand map drawing authority back to the Democrat-controlled legislature. If it worked, they could engineer districts that favor themselves for the rest of the decade. They would get to pick their voters instead of letting voters pick them. But here is where the plan ran into a wall, and the wall turned out to be the Virginia Constitution itself. Virginia has a very specific, very strict process for amending its state constitution. You cannot rewrite the fundamental rules of the game just because your party won an election. The Constitution lays out a clear, deliberate sequence, designed precisely to protect voters from self-serving power grabs. Here is how that process works. A proposed amendment must first pass through the legislature. Then, and this is the critical part, there must be an intervening election, a real one, where voters go to the polls and choose their representatives. Only after that election happens can the newly elected legislature vote on the same amendment a second time. And only then does it go to voters for final approval. That structure is not an accident. It is a safeguard deliberately built into the system by people who understood that majorities are tempted to make themselves permanent. It forces any major constitutional change to survive a real democratic checkpoint. It slows things down on purpose. It gives voters a genuine chance to weigh in before power shifts. Not just a theoretical chance, but an actual, informed, meaningful one. So now, what actually happened? In late October 2025, the Democrat-controlled Virginia legislature passed the first resolution on this amendment. Then, in January 2026, the new legislative session passed it again. On paper, it looked like the steps were followed. One vote, an election, another vote, then to the ballot. But a state trial judge saw something the amendment supporters were hoping nobody would look at too closely. And it comes down to one question, a question that sounds almost too simple to matter. What counts as an election? Here's the detail that changes everything. Virginia's 2025 election did not start on Election Day in November. Like most states, it had weeks of early voting. Voting began in September 2025. Mail-in ballots went out. Early in-person voting opened. Thousands of Virginians had already cast their ballots before October even arrived. Now hold that in your mind. Because when did the legislature take its first vote on this amendment? Late October 2025, right in the middle of that early voting period, while people were already standing in line, while ballots were already being filled out and returned. So here is the core of the legal argument. And listen carefully because this is where everything turns. If the election had already begun, if votes were already being cast, then the legislature did not vote before an intervening election. They voted during one. And that shatters the required constitutional sequence completely. The whole point of the rule is that the first legislative vote must happen first, then a complete election must follow. Not during the election, not overlapping with it, before it, the separation must be clean. That is what makes the safeguard real. Republicans presented proof that some voters had cast ballots in September, weeks before the legislature even voted on this amendment. Those voters stood in line, filled out their ballots, and made their choices without any awareness that this sweeping change to the redistricting process was coming. They chose their representatives blind, without the chance to factor in something that would reshape congressional representation in their state for the rest of the decade. That is not the informed democratic process the Constitution was built to protect. It is the opposite. The trial court agreed and struck the entire thing down. The case went to the Virginia Supreme Court. Oral arguments were held. And then came the ruling. In a 4-3 decision, the Virginia Supreme Court affirmed that the process was fatally defective. The amendment was invalid, the referendum was nullified, the current maps stay in place for 2026. But here is where this story takes a turn that almost nobody saw coming, because up until this point, this looked like a contained state-level fight, a legal dispute that would stay inside Virginia. Important, yes, but limited. And then something happened at the national level that changed the entire conversation. In a completely separate case, one involving Louisiana and redistricting timing, Justice Ketanji Brown Jackson wrote a dissenting opinion. And what she wrote addresses the exact question sitting at the heart of Virginia's fight. Now think about that for a second. This is not a justice anyone would expect to be providing legal ammunition against a Democratic redistricting strategy. Not even close. Justice Jackson, appointed by President Biden, is someone whose opinions are typically celebrated on the left. But legal reasoning does not always cooperate with political expectations. In the Louisiana case, the issue was whether election procedures could be altered after ballots had already started flowing, particularly to military and overseas voters. Some had already been filled out, some had already come back, and the question was whether you could legally treat the election as if it had not started yet. Justice Jackson's position was direct, detailed, and grounded in the practical reality of how millions of Americans now participate in elections. She rejected the idea that an election is just a date on the calendar. She rejected the notion that everything before Election Day is a legal waiting room where nothing counts. She rejected the formalistic view that treats real voters making real choices as somehow not yet participating in a real election. Instead, she focused on what was actually happening, on what voters were actually doing with their ballots in their hands. Once ballots are sent out and voters begin casting and returning them, she argued, the election is not approaching. It is not about to begin. It is already underway, already in motion. Right now, apply those exact words to Virginia. Early voting opened in September 2025. Ballots went out, people voted. The legislature's critical first vote, at the one that was supposed to happen before an election, came in late October, after all of that had already begun. If an election starts when voting starts, then Virginia's legislature voted during the election, not before it. The required constitutional separation was never clean. The safeguard was never real. Now, technically, a dissenting opinion from the U.S. Supreme Court is not binding on a Virginia state court. Nobody is claiming it is. But in the legal world, there is something called persuasive authority, and it carries real weight. Courts do not operate in isolation. They look at reasoning, they look at logic. They examine how other judges, especially at the highest levels, have worked through similar questions. When a Supreme Court justice lays out a clear, carefully reasoned argument about when an election actually begins in the modern era, that reasoning travels, it influences, it shapes how future courts approach identical tensions. It does not arrive with binding force, but it arrives with intellectual weight that serious judges take seriously. The facts here are nearly identical. Votes already cast, the process already in motion, legal action taken during the voting window rather than before it, the same core question at the center, and here is the irony that lawyers, judges, and political observers are still processing. The reasoning now being used to reinforce what the Virginia Supreme Court did, the intellectual framework that gives the ruling its clearest modern justification, comes from a justice that every instinct in the political world would say should be on the other side of this fight. That is not spin. That is what happened. And it matters because it shows something important. Good legal reasoning does not check which team benefits before drawing its conclusions. Justice Jackson was writing about election integrity and the real-world mechanics of modern voting. She was not writing to help Republicans in Virginia. She was writing what the logic demanded, and that logic now cuts in a direction she almost certainly did not anticipate. That kind of intellectual consistency is genuinely rare right now. It deserves to be recognized. So what does all of this actually mean on the ground? Virginia's current 6-5 split in its congressional delegation stays intact heading into 2026. Instead of a potential 9-2 or 10-1 Democratic advantage engineered through aggressive gerrymandering, both parties will compete on relatively fair maps. In a narrowly divided Congress, that matters enormously. Every single seat is leverage. Virginia's 11 districts represent a genuine tipping point for which party holds the majority after the 2026 midterms. The difference between a competitive map and a captured one is not just abstract politics. It translates directly into committee chairmanships, legislative priorities, budget decisions, and the balance of power in Washington for years. The difference between a competitive map and a captured one could be the difference between Republicans holding a narrow House majority and Democrats flipping control entirely. By preserving the independent commission's work, the court protected something more valuable than any individual seat. It protected the principle that voters, not politicians, should have the primary say in how their own representation is shaped. Now step back from the partisan noise for a moment, because both parties need to hear what this ruling is actually saying. Republicans who are celebrating today need to understand something. The process that saved them here is the same process that would constrain them under identical circumstances. If a Republican-controlled legislature in a red state tried the same procedural move during an active voting window, first vote taken while ballots were already being cast, the same logic applies. The same constitutional requirement would be violated, the same court challenge would be waiting. The win here was not for a party, it was for a procedure, and procedures cut both ways. Every time one side defends process only when it benefits them and attacks it when it does not, they chip away at the very foundation they might desperately need the next time the other party is in power. Democrats, on the other hand, need to take a hard look at what this effort cost them. Virginia voters approved the Independent Redistricting Commission for a reason. They voted for it. They put it in place specifically because they did not want politicians drawing maps in their own favor. Trying to undo that through a fast-tracked constitutional amendment, one that slipped its first vote in while people were already voting, undermined the exact democratic values many on the left claim to champion. Losing this case in court is one thing. The deeper cost is in credibility. In the public perception that when any party gets enough power, it immediately tries to lock that power in permanently. That perception, right or wrong, drives voters away from institutions they should be able to trust. The real winner in this story is not red or blue, it is the constitutional system itself. This ruling also carries a loud message for every other state watching closely. Mid-decade attempts to bypass voter-approved reforms or independent redistricting commissions will face serious scrutiny. Courts are increasingly unwilling to rubber-stamp procedural shortcuts, especially when those shortcuts undermine the very safeguards voters put in place to protect themselves from exactly this kind of move, and that matters in an era when trust in elections is genuinely fragile. When politicians bend or appear to bend the rules to entrench their own power, cynicism grows fast. It fills the vacuum. People stop believing the system works for them. They start believing it is rigged. And when moves like this one succeed, that belief is not entirely wrong. When courts step in and enforce clear constitutional procedures, when they say the rules are not optional, not suggestions, not starting points for negotiation, that cynicism gets pushed back. It tells citizens that the written Constitution still has teeth, that it still binds the people in power, that the safeguards voters put in place to protect themselves actually function when they are most needed. The Virginia Supreme Court's ruling does exactly that. It says the amendment process is not a suggestion. It is a binding requirement. It is there to protect democracy from its most predictable enemy, the natural temptation of whoever holds power to make that power permanent. Now, make no mistake, this fight is not over. It was never going to be settled in one ruling. Supporters of the amendment can try again, and they probably will, but the next attempt will have to be done honestly, transparently, with the proper sequence followed from the very first step. The first legislative vote happening before a single ballot is cast, a full election cycle in between where voters know exactly what is on the table, and then the second vote in a legislature shaped by a fully informed electorate. That is the process. That is what the safeguard demands, and there is nothing wrong with using it correctly. The objection was never to the goal of changing redistricting rules. The objection was to trying to shortcut the process while the people most affected were already in the middle of voting. What this case ultimately forces everyone to confront is a question that goes far beyond Virginia and far beyond this amendment. As elections change, as early voting expands, as mail-in ballots become the norm for millions of Americans, as the voting window stretches from days to weeks, the legal definition of what an election is has to keep pace with reality. You cannot have a system where weeks of real, legitimate, counted votes are treated as legally meaningless, where that entire period becomes a window for political maneuvers that technically claim to happen before the election while voters are actively participating in it. That gap between legal definition and lived reality is exactly where manipulation becomes possible. It is where timing can be used as a strategic tool without technically breaking any written rule. And the only way to close that gap is for courts to look honestly at what is actually happening when voters are voting, which is precisely what the Virginia Supreme Court did here, and what Justice Jackson's reasoning gave them a framework to do. Justice Jackson put that reality into clear, specific words with unusual precision, and those words, written in a case she never imagined would connect to Virginia, became part of the intellectual architecture of this ruling. That is how the law is supposed to work. Ideas travel, reasoning matters, consistency across ideological lines is what gives legal arguments their lasting power. Virginia's independent commission survives. The maps hold for 2026. The constitutional guardrails held firm when the pressure was highest and the stakes were most real. And a justice writing in a completely different context, about a completely different state, in a case with a completely different name, gave courts a modern and honest framework for understanding when an election is actually underway. This is the story that deserves more attention than it is getting, because it is not just about 11 congressional seats in one purple state. It is about whether the written rules of democracy actually mean something when power is on the line. It is about whether a constitutional process designed to protect voters from sudden, self-serving rule changes still functions the way it was meant to. It is about whether courts will look at modern elections clearly, at what voters are actually doing, not just at what the calendar officially says, and use that honest assessment to protect the integrity of the process. For now, in Virginia, the answer is yes, they still do. And that, in the end, is the most important breaking news of all. If this breakdown helped you understand what is actually happening behind the headlines, hit the subscribe button right now, because this is exactly the kind of story we do here every single time, connecting every dot so you walk away knowing more than when you started and understanding why it matters. Drop your thoughts in the comments below. Do you think both parties would honestly apply this same standard if the roles were completely reversed? I want to read what you think. This is the kind of question worth debating. And share this with one person who needs to understand what is actually at stake heading into 2026, because most people are going to miss why this moment matters as much as it does.